defendant's motion conclusively disproves or explains away the plaintiff's contentions. Simply put, defendants have hardly met their burden to warrant a dismissal in this case. So that seems to be the meaty part that you guys like, and it's a good little section there on what kind of deliberate indifference really comes down to, right? I mean, the plaintiff could be seen daily by a doctor who does nothing to help him and would clearly present a viable deliberate indifference claim. Regarding their qualified immunity argument, defendants, without support or citation, again, this is not really all that important to us. They lack the requisite state of mind for deliberate indifference. Curiously, defendants argue the plaintiff's complaint lacks specific facts to establish deliberate indifference. The court notes that the defendants do not offer any legal support for their state of mind argument. Okay, boilerplate legal recitations about immunity. Nevertheless, court finds the complaint is adequately specific. Okay, for example, and they go through some of these, deliberately disregarded and ignored the elevated ACE test results, knowing that such disregard was contrary to the plaintiff's serious medical needs. Plaintiff further alleges that Dankwa knew his failure to treat the plaintiff's sarcoidosis would cause severe permanent damage to plaintiff's one useful eye. Plaintiff alleges Nurse Schaefer falsified medical records, which affected the care he received. And further, plaintiff alleges that providers outside of the BOP were concerned about care he was receiving in BOP's custody. Taking the factual allegations as true, as they do in these situations, so they're basically, we're the non-moving party, they're going to take everything we say as true. The court finds that he has met his burden to survive defendant's motion to dismiss. So, again, curiously, she didn't say motion to dismiss and motion for summary judgment, although there's hints at that they would have survived motion for summary judgment at this phase.
Right.
That's kind of where we're at in the case. So, a couple things. One, I know we want to file a notice. I want to take a look and see. My only concern is how much we're filing at this point. But, we'll see. Let me give that a read over the weekend, and then we'll probably file that on Monday.
Okay, great.
The other thing that we need to talk about, and I think the more honestly pressing issue, because at this point we have been in litigation on both of these cases for quite some time, is if we want to add Garib and Lingo-Lay to the FTCA claims, we need to start booking on that. Okay? And we need to see what the law is on amending a plaintiff defendant in at this point, this late stage. Because, we're surviving a motion to dismiss. Okay? Right. And by the way, I didn't tell you guys this yet, but I have spoken to Max. Okay?
Oh, yeah? What did he say?
So Max, was surprised by the tone of the order. Felt like, obviously, it felt like that it, on the one hand, he understands the position of the court. He feels like Gina Grow is exceedingly hard to predict, okay? That she does not like the government, okay? And while he's surprised at this, he's, I guess, in the same token, not too surprised, if that makes sense. He's not like Tim Lincoln's. Tim Lincoln thinks you have no claim. Like, nothing. That Tim Lincoln thinks that you're full of shit.
Who cares?
No, but I want you to understand who the players are.
I know. Go ahead.
But Max doesn't think you're full of shit. Max thinks you have a legitimate claim. Okay? Max had, and that's the difference between Max and Linkus. Linkus is fighting you at every turn. Max didn't put in a motion to dismiss on the FTCA for a reason. He answered. Okay? He believes that you have a legitimate claim that you deserve to be compensated for. Now, what that compensation is going to be a point of contention, right? But he thinks that you do have a claim. And he thinks that you probably have a Bivens claim. He said, look, Ron, I'm going to throw everything at you on Bivens. But I'm going to concede on the FTCA to a great deal. And it's only because there's an internal policy within the DOJ that we protect our doctors. Okay?
They don't protect no constitution. They're not to protect no doctors that commit constitutional violations.
Well,
that ain't their job. That ain't their job.
Well, but see, what you gotta kind of brace there against is that it's their job to stand in and defend anybody and everybody, right, who they employ. Okay? So even against alleged constitutional violations, just because there's an alleged constitutional violation, and hell, even if there is an alleged constitutional violation, they don't roll over on this, right?
Fine,
they're gonna play.
Don't roll over one way or another. But anyway, go ahead.
Well, let me put it this way. I think now we're going to get to a position where we're going to start negotiating, a settlement offer, and they're going to have to come to the table with a settlement offer that reflects our position, procedurally in the case, right?
Right.
We've just won a motion to dismiss. We're in discovery on both of these claims, okay? We're looking at, a score of depositions, experts, we're looking at, starting to fully litigate and develop this case. And on the one hand, my contention is that, look, the records speak for themselves. I think they establish a prima facie case against your clients. The question largely becomes, outside of the experts, what's the benefit of depositions of your clients? They're just going to say, no way, we didn't do it, or they're going to, just confirm what the medical records already say. Or if they don't confirm what the medical records say, then that doesn't look good for them because that just strengthens my position with medical records, right?
Right.
So at the end of the day, it makes them look like, and their credibility goes down too, right?
Right.
So at the end of the day, I guess my question becomes to Max is, well, where are we at on this? And, why are we, twiddling our thumbs? Again, expert testimony is going to be something that we're both, you know as well as I do, deposing an expert, you're only going to get their side function. You may mitigate it slightly. You may get them to move off an extreme position, but you aren't going to necessarily, hold on one second, guys. Phil, did you park out on the street? Okay, good. Okay, good. Because they're blocking off the street. No, so, it's going to be a conversation with Max. He is getting an expert right now. Okay, that's what he's told me. His next step is to get an expert. He wants to have a conversation with an expert about your case. And once he does that, then he's going to come back to me, and we're going to have a substantive discussion of where we go from here. Okay? I would very much like to file in the interim that motion to amend in Garib and Lingolay under the FTCA. Okay? I have not read these memorandum of opinions on Pledger that just came down out of the Southern District, but I'm going to this weekend. Okay? And if these are diversity cases, right?
Right.
So Tim, just so you can kind of get an idea here, so there are, Pledger is an FTCA case, okay? So it's a federal question jurisdiction. It's not 1983, which is what we're pleading in the Southern District against Lingolay and Garib.
Is it a 1983 and Bivens is the same, right?
No. The only difference is a Bivens is against a federal employee.
Right, and then it's but it's.
And I actually, the more I think about your case, is you probably have. This is probably all FTCA, all Bivens. Okay, it's not necessarily a 1983 because state actors acting under the color of state law, they're quasi-state actors, I guess, because they're WVU. But they were quasi-federal employees in the sense that they were, working on you from a perspective. So, we got to sort that out. But at the end of the day, the 1983 Bivens distinction, there is a distinction. Just the question is does Pledger apply to both equally, right? or does we don't know that Pledger applies to Bivens yet. Okay, we know that it applies to FTC.